I think that this filing requirement will help brokers. It'll have leverage over issuers, because the other day, the filings we get today for broker dealers, the MPO filings, we got 400 in the first year. I spent 2 days, I sat down and read 60, I think, PPMs, and you guys are in the business, you guys and gals in the business. You know, some of them are great, and one of them, 18% guaranteed return. Lisa, get in here. We need an 8210 letter. I think that it'll be kind of self-policing in a way, because a broker will say to an issuer, I can't file this piece of crap, with FINRA. So I think that hopefully will make a difference. The filing requirement in and of itself will make a difference to get more and better information in the PPMs. We got a comment in, and I'll have to think about this. Somebody said it shouldn't apply to low-income housing tax credit offerings. So let's consider that. There is a very long list of exceptions. For example, if you're selling to the issuer's own employees, accredited investors we want to keep, but larger investors, investment companies, regulated industries, insurance, and so forth wouldn't be subject to the filing requirements. But as I say, I guess the comment period expires in 2 weeks. We will, I promise, listen closely. So if any of you want to comment on the proposal, please do. It's give and take. We want to. I started this way. I'll end this way. I really want to improve the market for raising capital for small businesses. Improve it and make it easier and more efficient, and have a result that more capital is raised, because we've got a market with fewer problems than what we've seen in the last couple of years. I'm going to speak. They said, I'm an accordion. I can speak as short or as long as anybody wants me. I one time went down to Mexico and spoke to their stock exchange and their SEC, and I showed up and I hadn't worked it out in advance, somewhat like this, and asked the young lady, well, how long do you want me to speak? And she said, 3 hours. So I just gave my hour-long talk 3 times in a row. But, we also, following the tech bubble, Harvey Pitt, who was then chairman of the SEC, asked the New York Stock Exchange and the NASD at the time, now we're all one company, we're FINRA, to form an advisory group and propose changes to the public IPO market. And finally, 6-7 years later, the SEC adopted the rules that we proposed for us that came out of that advisory committee. It was a fun advisory committee because Dick Grasso was on it, and at the time, I just felt like my career as a regulator, I'd stumble along and try to get my kids through college, but once I met him in person and he got fired for how much money he made, I thought, well, now that's my new career goal. I want to make so much money that the minute people hear about it, I have to be fired. I'm a long way off. In any case, I'm not going to go and talk much about all the provisions. Some of them were directly related to the tech bubble, which, we haven't had an IPO market like that since 2000, but quid pro quo allocations are prohibited. They were prohibited anyway. We brought a lot of cases where people were paying exorbitant fees over a trading desk for their portfolio and other trades in an effort to get the IPO shares allocated to them. I don't think there's any big deal there. We have a flipping provision The reason it took so long to get the rules adopted is the SEC went out and proposed their own amendments to Regulation M, and then they were never able to, or just never decided to pass them, so we kind of waited. We have a provision that says if there's a penalty bid, you can't just do a penalty bid on the retail side. If there's a syndicate penalty bid, it's fine, but you can't just discriminate against retail. Now, the SEC's proposal was to do away with penalty bids altogether, but they didn't adopt that. So penalty bids can still be done consistent with the rules, but not in a discriminatory fashion that focuses on retail. Notice about waiver of lockups. There was a little confusion about that because sometimes the lockup, share subject to a lockup may be re-registered and sold off of a registration statement, and so there were some issues about saying, prior to that registration statement being filed with the SEC, it would be gun jumping, so we would consider that. But, basically, it's just if you're going to waive a lockup, you have to tell the market prior to doing that. Return shares, we wish we had these kind of problems today. There's a problem, some shares would come back, and they were, the IPO was at such a high premium that it gave the firms the opportunity to, confer this valuable benefit. That's not happening as often today, but we said that if that happens, you should use it to offset the syndicate short position, or if you don't have a syndicate short, in the unlikely event you don't have a syndicate short, randomly allocate those shares to the indications of interest. And then no market orders could be put in prior to the IPO trading. Remember, I don't know if now it's ancient history, but I think it was Fog Hat, when it opened at $260 on the first trade, and people who had put resting market orders in got creamed. The institution said to us, well, we would never do that. And we said, well, if you would never do that, let's just say, retail investors can't do it either. The difficult part of this rule, I think the only difficult part of it that I've gotten feedback on, is it's got a spinning provision. And it says you can't allocate shares to the executive officers or directors of companies who are your investment banking clients or who may be your investment banking clients within the next 3 months. And that's creating some operational difficulties at some firms to identify who those clients would be. So this isn't for sure, but right now I've seen a draft that we would send to the SEC where we're going to ask that the spinning provisions not take effect. The rest of the rule becomes effective in May. We're going to say that spinning provision shouldn't take effect until after Labor Day, just to give firms an extra amount of time to be able to get their offer, even though I think that the rules were adopted in October, so October to May was a long time, but firms want some extra time, and took, 6 years to pass the rule. I think some extra time is reasonable. Let's talk about some interesting, I'll finish up with some interesting things that are going on. One project that we're working on, and I'm going to talk, I have let's call it a corporate financing committee of industry participants that give us input, and we're working with them. I'm going to talk to them next week about rights of first refusal. This is in public deals. Under the corporate financing rules for public deals, an unreasonable term and arrangement is to get anything more than out-of-pocket, bona fide out-of-pocket expenses for if you're terminated, if the deal doesn't go forward. In this market, firms put in a lot of work before they get paid, and then sometimes the deals don't even come to market. And foreign deals require a lot. And the idea is, well, we probably can't get paid until we raise the capital because it's just too expensive for the issuer, so we need to get paid. We'll do all that financial advisory work in advance, but we need to get paid out of the proceeds. So we are going to, we're working to come up with a way that firms, to amend the reasonable terms and arrangement provision in the rule so that firms could enter into engagement letters with issuers that said if this deal doesn't go forward, and we're terminated for some clause like a market event, unrelated to our being negligent, we do get a right of first refusal to participate in the next deal. The SEC, as you know, after Dodd-Frank, was required to strip out credit ratings from all their rules. We have provisions in the corporate financing rule that have many exceptions, and our conflicts of interest rule 2710, that are provided for deals where the securities are investment grade rated, or their offerings by issuers with investment grade ratings. I'm not sure what we're going to do. We're keeping a close eye on what the SEC is doing, but I think if they strip all those references out of their rules, eventually FINRA is going to feel like we should strip them out of our rules too. And then finally, I mentioned 1022 that we published last year. 1022 is nothing new about due diligence. Instead, and some of you have heard me say this, I had a stack of cases probably 2 feet high on my desk, and I went through and just read all the cases. And then we sat down and said, what do these cases say about due diligence responsibilities in private placements? And then we put that down in the notice, what we thought the cases stood for, because there was never even a law review article written about due diligence responsibilities in private placements. We sent that over to the SEC. They read it, they sent it back to us, and we published it. I haven't, maybe you guys have some stories to tell. I haven't heard much since, other than, hopefully people are doing more thorough due diligence. I had a public deal come through that was a Chinese pharmaceutical company. Actually, it was a Tibetan pharmaceutical company. And listed as underwriters counsel was a particular law firm, and then issuers counsel was the same law firm. And we got the contracts. They were under contract with the issuer, and they were underwriters counsel. And we called them up and said, we're not going to clear this deal. Called over to the SEC, got trading markets people and corp fin people, and said, that's going to be our policy. There's no way you can do independent due diligence for an underwriter if you're working for the issuer. That said, and that's a point that we make in the notice, that said, a particular lawyer could file a deal and manage a deal. For example, unlisted REIT deals usually are managed by just one broker, but you can't work as issuer and underwriters counsel simultaneously, because that wouldn't be due diligence that meets the requirements.